Good day to you. Today we're going to talk quickly about sectional title meeting minutes. There is an obligation on trustees to create minutes, to keep them forever and to make them available. Prescribed Management Rule 34.1 provides that the trustees must keep minutes of their proceedings, keep minutes or cause minutes to be kept of all body corporate meetings, and that must be in a minute book kept for the purpose, and the minute book must include details of every unanimous resolution, every special resolution, and any other resolution of the body corporate. 34.3 requires the trustees on written application of any owner or registered bondholder to make the minutes available for inspection. PMRs 34.2 and 35.2 require that the minute books be retained as long as the scheme remains registered or in perpetuity. And PMR 49.2 obliges the trustees to give any managing agent copies of the minutes of all meetings of the trustees and of the body corporate. So what are minutes? Well, they're the body corporate's record of its written record of its decisions, detailing the business, the formal business that it has done. Once confirmed, they are considered to be evidence of their content. So somebody who considers a confirmed minute to be wrong, the obligation is on them to prove that, not on, there's no obligation on the body corporate to prove that. The normal content starts with a heading, a date, the body corporate details, the place and time, a list of those present and their roles, and each agenda item, with at least a record of the resolutions taken. In what form must they be kept? Well, traditionally, they were kept in paper, books, and you'll see that the prescribed management rules still quite clearly intend that to be the case, a traditional minute book. But now, in practice, they're often kept digitally. In whatever form the minute book is kept, it must be capable of being rendered as words on paper and kept so as to prevent change and allow for notations, for example, when a decision is reversed. And what sort of level should be included in the minutes is a question often asked. Well, clearly the text of resolutions. The names of proposers of motions, not necessarily, although it's not unusual to find this, and it can be useful. A summary of the debate, well, less often this proves useful, and very often in this area that people wander into subjective commentaries on why people said things. So this can be a dangerous area. Should the voting results be recorded? Not necessarily, but if it's a very contentious issue, probably should. And one thing you shouldn't include is details of things that have happened after the meeting. Very often people who write up the minutes are the same people who are told to go and do things at the meeting, and they go and do those things, and they then include in the minutes, oh, and I did this, and that was the result, or whatever. That's not for the minutes. That's for some subsequent report. You mustn't confuse the two. And who must confirm or sign the content? Well, traditionally, this happens at the next meeting of the same body. But the practicality of sectional title management, especially in regard to AGMs, is that there probably isn't going to be another general meeting for some considerable time. So at the next trustee meeting, these things are normally confirmed because they've got to be acted on. Nonetheless, the traditional situation is that only the same meeting can confirm the minutes of a meeting. Thank you very much for watching this video. Let's discuss the issues in the discussion forum.